on the appeals one.
No, re-appeals, we have 065-19.
Okay, so
those are, I brought them to your attention because I'm always unsure whether Mr. Arison actually sends things to board members as he puts in his address links. So I wasn't sure whether you wanted to treat these two letters or these two emails on these cases as an appeal, or
well, they don't
as a reopening, or what you wanted to do with them. I just wanted to make sure that they weren't left unattended so that it created a different issue for Mr. Arison.
Well, Mr. Arison's going to find an issue no matter what we do, so let's just do what we want to do anyway.
So, well, this is the way, this is the way I was thinking about having, since there's two numbers, I guess one at a time, is this letter to this CPOA board, please clarify how body were able to provide administrative closed cases related to complaints CPC 065-06619 during July 16, 2019 special meeting when I was not introduced in those CPC investigations as required by paragraph 183 of the CASA. And I don't know if it's your decision, Director Harness, if you just want to answer the question on these two cases. And then
he's asking us why.
Sure.
Yeah, if you could just.
Well, I mean, I'm the investigator for both of the cases, and I administratively closed them.
Right.
He's making a third-party complaint. The first one is a case where I initially did not open an investigation because there was already a internal affairs investigation being conducted.
6619.
Right. So he brought it back again, and so there's nothing that he has of any evidentiary value for me to interview him.
And for 0619, you answered his question in the first letter that said that the Brady list, which is the point he brought up, is required of the DA, not APD. That the standard is that APD will cooperate when requested.
Correct.
So there is nothing here to do.
Right, and there's nothing that he has to offer of evidentiary value for me to interview him, because well, he offered as evidence a writing from a legal website, and I found many other writings that refute the writing that he offered.
Yeah, well, we're not in the business of settling the issues of law.
Right, and aside from that, he could.
Does he have standing?
There's no specificity for anybody who would be responsible for that within APD. So he would need to tell us, Commander so-and-so is in charge of this, and they're not doing what they're supposed to be doing, as opposed to APD.
Right. So that's never caused him, having standing or not, has never caused him to step away from a microphone. And so my point is he doesn't have standing in either of these cases. He has no evidence in the first place to offer, nor is his, and it is inappropriate for us to investigate an IA investigation. If we choose, we can, once that investigation is over, we could pull that for examination if we wanted to. But it is not an obligation on our part. In fact, it's inappropriate for us to do it. So that is the answer to his question, none of which is related to an appeal. So he hasn't met any of the criteria for an appeal, let alone a legitimate complaint. So I would just applaud your efforts to give him the information and move on.
No, I agree. I just felt if Director Harness can answer his question, and he's answered it.
Okay, 132.18.
Sorry, real quick. Is there a motion for denial?
Well, we can just do all of them at once, can we?
Okay. I don't know.
Okay.
Do you have to do them
No, we'll do them separately.
Okay.
So, case 065-19, do I have a motion?
I move that we are satisfied with the actions of the agency and disagree with, if this is an appeal, we are denying it.
Well, you'll recommend to the board.
Yes, that's what I mean.
You recommend to the board. Okay, do I have a second?
Second.
All in favor?
Aye.
Now, 066-19, do I have a motion?
The motion is that this case is under an IA investigation and is therefore inappropriate for the CPOA to run a concurrent investigation, and therefore the agency is doing as it should.
Do I have a second? All in favor? Aye.
Aye.
Okay, next we have 13218. Do you want to pass this to Ed? I don't know if you received a copy of Jim Larson's email that was sent out on September the 2nd, 6/19. Instead of reading his email, I think I'm just going to give you a copy just to attach to the minutes. Is that okay? For our next meeting?
Isn't this an appeal?
Yes.
And so, okay, let me start with this. I think, the board needs to decide if an appeal is granted. And I still think an appeal is warranted, but I don't think we should, since just Joanne and I are the only board members, Chelsea's not here, and I don't know how familiar you are with this case. I think we should just, move this case to the non-consent agenda for the full board to decide.
There's nothing new here, is what I'm thinking. So, we've already denied an appeal, haven't we, on this? No, we haven't.
No, we haven't.
I thought we did.
No, we granted an appeal.
And didn't the board vote on it?
No, the findings for this case went out from the special meeting. It has never been, the board's final product was from the special meeting, so therefore the appeal process couldn't start until he received his final findings letter. So there has not been an appeal in this case. He's appealed.
So why is it here?
He's appealed.
This is the appeal.
This is his appeal.
This is his appeal.
Right.
Okay, so we've beaten this to death. We really have, as far as I'm concerned. And I have, out of all of the things that Mr. Larson has said and claimed, I think that the findings letter actually does answer his questions to the extent that it is possible to answer his questions. I think there are two questions that I have, and that are not necessarily, I just need for my edification, I need to understand the answers. I think the contention that he has that the child, just as the general public, is the child the only verifier of abuse? Because the reason that more investigation wasn't done, was stopped, was a line was drawn in the sand when the child said there was no abuse. Is that the only reason to go ahead or not? Is that a stop? Is that a hard stop? Because I want to know what the law says relative to that.
Well, it's going to be on a case-by-case basis, and in this particular case, there was a determination based upon the investigators from APD and CYFD that there was not probable cause nor reasonable suspicion to believe that a crime had occurred.
Okay.
However, in other cases where there are other circumstances that could come into play to develop facts and to develop evidence may not hinge on whether or not the child comes forward with allegations of abuse.
In this case.
Correct.
Is there a misstep by anyone, CYFD, APD, CACU, whoever, that could have been pursued once the child said no?
For that particular day? No.
You mean the school day, the day they found the underwear?
Right. Remember, that was 24 hours later when they went out, so.
So is your answer to my question that sometimes the child can stop the train by not?
Sometimes.
And other times not? Help me understand the
Yeah.
difference between the two.
It's just, I mean, it's going to be a case-by-case basis on whatever facts that you can develop.
I don't
I mean,
understand.
and, I don't want to go down the what if.
No, just on principle, I'm talking
yeah,
about structurally, not necessarily.
Not structurally, no. I'm structurally, if you can develop facts from other sources, then, and you can develop evidence, then no, the child wouldn't necessarily be the stop. But in this case, the child was the stop because there wasn't anything else to go by.
And all of that goes into the decision that you just said, which was APD found nothing and CYFD found nothing. Therefore, there was nothing.
For this particular incident, yes,
And that's the reason to not go forward.
yes.
And had she said, see, it just seems to me like the system is relying on the ability of a 7-year-old to acknowledge in some unusual circumstances, in front of her brother, in front of her parents, that something happened. That defies logic for the general public. And so that's why I'm asking the question.
But the interview was not conducted in front of her parents. The interview was conducted,
Well, part of it was, and then she was taken out into the hall, right? And interviewed separately by someone with some training in general, like that bothers me, that designation of special units to address special issues, have special training. And it feels to me like when you say that an individual had some training, which to me sounds like as part of a general training, they did a section on how to talk to children in sensitive situations, and he probably implemented some of those. But why would the Crimes Against Child unit exist if it didn't take more than that, right? In order to, like, I think these things may be more finessed than just what you might pick up in a general training and have a little bit of like, oh, I understand I shouldn't word things in certain ways. But I find that part of the determination letter mentioning that the officer had some training.
It
doesn't feel.
I know you understand what I'm talking about. I understand how much work went into this, and I get it, that certainly it is our job to assess whether or not their actions were reasonable. The part the public will never get until we answer this question is, how does that call get made? Because it appears in the letter, in Mr. Larson's complaints, in all of it, that because she didn't confirm it, it couldn't go anywhere. And if that's not always true, then we need to understand what's the difference between stop here or don't stop here. And I would invite your suggestion to bring it before the board and ask somebody from CACU to come and talk about that. Let's ask them. I understand why your findings letters are what they are. You know, certainly the CPOA can't decide that it should have gone somewhere else, you know, if those two agencies decided it shouldn't. But my question is, the public is left still not understanding how a 7-year-old who might be terrified could stop an investigation, period. That is the kernel that's missing.
But that's not the only kernel that's involved in this particular instance.
Help me understand it.
I mean, this is discarded clothing from 24 hours previous. And so there were many factors involved in this one particular day, in this one particular investigation. So it's not simply that as the public perceives that there was this stained underwear, which has never been confirmed to be blood in the first place.
Well, it can't be because it doesn't exist anymore.
I'm sorry?
Well, I mean,
Well, okay, and what those origins could be, it's not necessarily that it could simply be from hygiene. It could be there are many factors that can come into play for this particular garment that is now being turned over, that was at one point discarded and then brought forth again.
Yeah, well, we're getting into the weeds and all
Well,
that.
but those weeds are particularly why there was this decision made. That's why every case is going to be a fact-based decision. And what are the facts that we have? What are the facts that we can prove? What are the facts that we have as evidence? And what do we have that is simply speculation? Speculation on behalf of a school teacher, speculation on behalf of a nurse who never did an examination.
I would really
So
urge
all
us
of those aspects, all of those led to that decision at that particular time.
Okay. Well, I think that what the public is left wanting, my guess, is understanding this particular point. And I would be prepared to have someone from CACU, CYFD, come to our board meeting and say, this is the circumstance in which this case is, because it appears that because she didn't confirm it, nothing else happened. That's what it looks like, okay? If there's other factors, we need to understand them. And if there's a case in which she could have confirmed and therefore it would have gone, and it's not that simple, fine, explain it to us. The public absolutely needs to understand, because you can do a lot of things wrong in a community. You mess with a child and you have lost the public. And I'm not talking about you, I'm talking about APD and CYFD. They owe the public an explanation on why this didn't go further. This wasn't the only call. There were other calls, and we understand that there was a portal developed and it wasn't working at the time, and if this were to happen again, how would it be different? We need to understand that, and until we do, we're just rubber stamping something that the public's already told us they think is offensive and wrong and unsupportive of children. So let's help them understand what the rationale is. Let's bring it to the whole board. This committee votes to bring it to the whole board for discussion. We invite somebody from CYFD and somebody from Crimes Against Children to explain to us why this case couldn't go any further. It shouldn't have gone any further. You're telling me it shouldn't have gone any further, right? Mm-hmm. So help us understand why. Does that make sense?
I agree.
Let's listen to what he has.
The legal standards are the legal standards as set forth by the law.
And I'm not asking whether or
I-
not you should have gone further.
I'm saying that's what the police relied on when they make their judgment. And that's what they relied on when they made their judgment here.
Well, then
The
help us
legal
understand
standard.
how the law as it exists hamstrings them. Help us understand that part, okay? This is something the community gives a big damn about. And we need to make it possible for them to get the information they need to understand it.
But that's not our role at the
Why is it
CPO.
not?
It's not. Because we're here to investigate officer behavior. We're here to make policy recommendations. We're not here in our role to educate the public about what legal standards are.
So
And-
if there's
and what-
something that is a thorn in the relationship between the community and the police department that could be understood better, it's not our job to offer that understanding?
Perhaps maybe the board sees their role as doing that, but I don't see that the agencies, I don't see that as our
No,
role.
no, and that's what I'm saying. The agency did what the agency needed to do. Fine. That's not the end of the story, as far as I'm concerned. We have an obligation to help enhance or improve the communication between the community and the police department. And if we don't do this, we have failed in our job, the board, not the agency.
Okay.
You understand?
Sure. I mean,
Okay, so who's the head of CACU?
I will have to get back to you on that because it's not
Lieutenant.
Lieutenant Parker any longer.
No.
It's someone else. She's gone.
Okay, and so we need CYFD. Who's the highest person involved in CYFD in this case? Who is the highest ranking person from CYFD?
I don't know. I'll have to look at the file.
Can you find out who those two people are? And do you want to call them and ask them, or do you want us to call them and ask them to come?
I think the board should do that.
Okay.
You can call them.
Okay. Okay, so for the purposes of this meeting, we are moving this, we are making a motion that we move it to the full board.
Yeah, to the non-consent agenda.
To the non-consent agenda.
Okay, I'd like to make a motion that we move case 132-18 to the non-consent agenda to go before the full board. Do I have a second?
Yes.
All in favor?
Aye.